Southlake, Texas, with Brandon McGee, who's an estate planning attorney. And he is my expert today because I have lots of real estate transactions where something's happened because someone has passed away, there is or isn't a will, and I get lots of questions from you all, and so I thought it would be great to have a conversation today with Brandon to ask the questions you all have been asking me. So, welcome Brandon, thanks for being my expert
Sure,
today.
Thanks for coming and including me in this.
Yeah,
Excited to do it.
and we just need to share with everybody, you and I always laugh. So Brandon has actually done estate planning for myself and my family.
Yes.
And we've discovered that we're both former litigators, and we both go, yay.
Litigators in recovery. Right?
We're glad we're not doing that anymore. But I always used to say that the best defense, because oftentimes I was representing on the defendant, the best defense was actually offense.
Right.
And I would tell my clients, you know, no matter who they were, we've got to get things documented ahead of time. We need to think proactively.
Yes.
And would you agree the same philosophy?
Yeah, absolutely. And what I tell people is pre-planning is always better than last-minute crisis planning. You just have so many more options. So in life, when you plan something out ahead of time, it's almost always going to go a lot smoother than if you have that kind of emergency crisis situation where you're just doing the best that you can. Everybody's kind of crazy and emotional. So yes, absolutely.
And especially when you're dealing with
death, yeah.
divorce, serious life matters.
Yes, absolutely.
And how many years have you been doing the estate planning?
So I've been practicing law for, it'll be 20 years in November. I've been doing pretty much exclusively estate planning for about 7 years now.
Long time.
I kind of started phasing out my litigation practice and then finally got to the point that I was doing pretty much just estate planning and probate.
Okay. So in those 7 years, would it be fair to say that you've seen a lot?
Yes.
And seen a lot that could have been avoided or minimized had there just been proper planning?
Yeah, particularly because in my practice, I also help families through the probate court. And so oftentimes those are families that haven't done the good planning. And so I see it every day. I see the negative ramifications of not planning all the time. And then I see the positive ramifications of pre-planning all the time. So I see both sides.
Okay. So for right now, I actually have a couple of cases, listings.
Okay.
Family wants to sell a house.
Okay.
And both of them, you talk about the roads diverging, you know, they're going very different ways because what was and wasn't pre-planned in these cases. So let me just start with the number one question I hear a lot, or a statement more, is, hey Brandon, you know, we live in Texas, we have a community property state, so whether we're married or we have a common law marriage, doesn't my spouse just inherit it, so why do I need to do any of this anyway?
Yes, there's several common misconceptions in estate planning, and that's definitely one of them.
Okay.
Is, you know, the husband will say, well, when I die, he's assuming he's going to die first, which doesn't always happen.
Right.
Then my wife just magically gets everything because we've been married for 45 years. And that's not true. There's no magically get anything. You either have to have things, when somebody dies, even if they're married, we need a way to transfer their marital interest to their spouse, whether it's the house, whether it's a bank account, whether it's their retirement accounts, whatever it may be. And if you don't do that, then you are going through the court system, period, end of story. So don't think that because you've been married for 45, 50 years that you don't have to do anything. You still need to set up an estate plan to transfer your interest in your assets once you pass.
Okay. So then the next thing often comes with, well, so let's say that, so I do have a case where the one spouse died, the deed was in both of their names, so their surviving spouse now wants to sell the property.
Right.
Well, we can't just put the house on the market and sell it because...
You have to clear title.
Exactly.
Yeah, so you with property in particular, you have to get this deceased spouse's name off of title. And so different ways that can be done. Number one, if you do things ahead of time, you can have your home in a trust where we can clear title real easy, or you can have a transfer on death deed where we can clear title pretty easy as well. If you haven't done those things, there's different, depending on if there's a will, if there's not a will, there's different routes that we can go, but usually doing doing something ahead of time is always the easiest route.
Right.
Okay.
Yeah, and in one case, there was a will, or is a will, and in another case, there is no will.
Right.
So both cases are complicated. Neither one of them
Yes.
had everything done ahead of time. So, and having to go to court, I'm going to assume, given my experience, that costs more.
Okay, going to court always costs more than setting up to avoid court, and going to court always takes a lot longer than not going to court. So, yeah, going to court is the case of last resort, and for a lot of people, it's not. They're not set up for that. It's just what's going to happen. But if somebody really wants to do a good job with their estate planning, court should be just a case of last resort.
Okay. So how do people avoid
the court system?
Yes.
So number one, when it comes to dying, we're talking about real estate here primarily today because you're a realtor, is either have your property in a trust or have a transfer on death deed for your property. I won't get real off into trust, and there's a bunch of other good reasons to have a trust. It's kind of outside of the scope of today.
Right.
But those are the two ways that you can do it. And so for some families, the transfer on death deed, I would say this, the more middle income families, maybe a transfer on death deed is sufficient. Some of the families that are a little bit maybe more upper middle class, affluent, however we want to say it, and up to wealthy families, usually a trust is better. So, But it just depends. It's all very personal.
Okay, so we have this wonderful thing called the internet.
I'm aware.
And people say, well, gosh, I can just go on the internet and I can download a power of attorney and estate documents. And what would your response be?
So I'll get up on my soapbox here. It's a terrible idea.
Okay.
I tell people that would be like if I wanted to be my own doctor. I have no training to be a doctor. But I just decided I'm never going to see a doctor, and I'll just get on the internet and do research about my health and go to Walgreens and buy medicines, and I never go see the doctor. Eventually, the chances that will backfire eventually in my life are super high, and it may not be till I'm 20 years down the road, but it's going to backfire. It's the same thing with legal documents, guys. If it is so worth the money to take a little bit of time and a little bit of money to do the estate plan the right way. Is worth every penny, because I've had disaster probate files. I have disaster probate files right now because people did documents themselves.
Okay.
People have documents from out of state. We have so many people moving into DFW right now from all over the country.
Yes.
You don't necessarily have to just toss your estate plan out the window when you move to Texas. You may need to, or maybe we can do some amendments and kind of get it cleaned up. But you definitely want, if you're a Texas resident, we want an estate plan drafted by a Texas lawyer.
Okay.
And we want to have, at our firm, we have check-ins every 2 years with our clients, reviews, and you want to keep pretty consistent with reviews because laws can change.
Right.
Circumstances in your life can change.
Right. And just so everybody understands, you and I are attorneys, but estate planning and so if there is no will and, each state's law, right? There's not one federal law that governs how things go as far as inheritance. It's governed by state law.
Yeah, great point, guys. So every state, all 50 states has their own estate planning jurisdiction. And so laws that are going to be different in different states. To some degree, they may be the same, but none of them are the exact same, and some are dramatically different.
Right.
Depending. So it's good. That's why you want to come in when you move into a new state. You want to get with a legal practitioner from that state, have him or her review your estate plan from your old state, and then follow their guidance on what they think you should do.
Right. And with respect to real estate, so we do have a lot of people and I have clients moving here, so they already own property in another state.
Yeah, California.
They're buying property here, so you've got two different states with property laws, but correct me if I'm wrong, the screen just went off, does that mean anything? Sorry guys. So if they own property in multiple states, and even though you just said state law is going to dictate, if they have an estate plan with a trust document, they get to decide and the state law wouldn't control.
Yeah, so that's a real important point. If somebody owns real estate in more states than Texas, and they haven't set up So those people end up, spending $25,000, $30,000 traveling between multiple states doing a probate.
Wow.
The solution to that is to have a trust,
Yeah.
to have your land owned by your trust. And it can be land from multiple different states. It doesn't matter.
Okay.
And then the land passes very quickly, very easily, and smoothly upon your death through the trust.
And not have to go to probate.
Yeah, you don't have to go to probate in California or Michigan or New York. So.
Yeah, so that's a huge, another reason why we want to do all that. So talk about, again, and something else that you and I are seeing a lot with our clients is blended families.
Yes, oh yeah.
How does that affect real estate and inheritance?
Okay, here's the main red flag with blended families, guys, is that if you have no estate plan, period.
Yes.
And your spouse has kids from a previous marriage, they're not your kids, then you are going to end up owning your home and everything else with your stepkids, who you may or may not like, and they may or may not like you, right? And so it's very critical for all of us, period. But especially, I think, blended families, it's an even bigger red flag and even more of a need for good, comprehensive estate planning, so that we don't have, you're not 82 and suddenly you find out that your stepdaughters, own the house with you, right? We've had a lot of problems with that too. We've seen people, those kind of problems. So very important for blended families to really get some good work done in estate planning.
Which kind of goes back to where we started originally, that everybody's assumption that, oh, my spouse gets it anyway.
Yeah. Yeah, especially if you have kids, if your spouse had kids from a previous marriage, that can cause big problems.
Gotcha.
Yeah.
Okay. And let's see, what else? You mentioned earlier about the warranty death deed. So is that something that you prepare? And
Yes.
Exactly how does that work?
So the transfer on death deed is a legal document, and it was allowed by our state legislature in 2015. And it will transfer upon the person's death their ownership interest in their real estate to their stated beneficiaries. So it's like any other deed, and so it really should be drafted by a legal professional. It's not a requirement, just like it's not a requirement that I don't perform open heart surgery on myself,
Right.
but I'm not going to. So it's better to have the transfer on death deed done by an attorney. So for our clients, it's very simple. They give us a little bit of information, we draft it, they come in, they sign it, and then we e-file it with the land records of the county in which the land is in.
Right.
When that person passes away, their family will contact me, and we file an affidavit of death and the death certificate issued by the state of Texas with the land records, and right there that vests ownership in the beneficiaries. Nobody spent one penny on an attorney or going to court.
Okay. So last, kind of with talking about the family part. So unfortunately, you and I both know families where the parents have died, leaving behind very young children
Right.
who are minors. So in Texas, that would be under the age of 18.
Right. Yes.
Correct? So what happens to the minors? And let's say there was a family, they own a house, and both parents die in a car accident, and they leave behind their children who are minors.
Yeah, good question. So here's what happens when somebody hasn't planned properly. What happens is we're going to need a legal guardian, right? Somebody who has legal custody, and it's going to have to come through the court system. Even if you've done your preparation, you still have to go through the court system to get that kind of authority. But if we have in place our choice of who we want, we can avoid family arguments, grandparents or whoever getting in custody battles, because we've seen that happen, right? And so that's number one. You're opening the door to a custody battle between family members. Number two, whoever that guardian is, whoever it becomes, they don't have an automatic right to your resources. They're going to have to go through the probate court system to ask the probate court if they can get access to the money to spend on the kids. If they do get that access, which they probably will, the court just kind of says, okay, here you go, here's a bunch of money, good luck, and there's really no oversight or strings attached.
Okay.
So then you run the risk of, this happens unfortunately all the time, people spending the money on themselves, people self-dealing.
Yes.
It's really sad how often that happens. If you leave a trust behind, and so for my wife and I, for example, we have twin sons who are 13, So we have trust terms for every phase of my kid's life. In case we die while they're still growing up, there's a set of terms, very specific. This is the guardian, this is the trustee. The trustee gives the guardian X amount of dollars per year, period. Okay, no more, no less. Then when hopefully they go to college or university, the trustee will not give them the money to pay the college, because we won't trust our 18-year-old sons to pay the college.
Right.
The trustee will pay the college directly.
Okay.
And then when they get older, I think we pick like late 20s through mid 30s, then we start distributing whatever may be left. So if you have kids, I really recommend a trust device, so that if you have kids that are minors, so that in case you and your spouse pass away while they're still young, we have something that can really control the situation and utilize your assets that you leave behind to the best advantage of your kids.
Right. And what would happen to the real estate? If there was no trust and hadn't been any pre-planning with the family house, what would happen?
So it would probably just get sold, and then the money would get put in a bank account for the estate, and then
But you'd have to go to court.
You'd have to go to court. Yeah, you'd have to go to court twice. You'd have to go to court to probate to be able to sell the house.
Okay.
Then the guardian would have to go back to court after it's sold to ask for access to the money. Then once they're given access to the money, there's very little oversight. There's very few rules, and then again, we hope that they don't squander the money.
Right. But you're spending a whole lot of money up front.
Yeah.
Just to make those things happen, which you would want to be for the benefit of your children.
Yes.
So all in all, you could save a lot of money for the benefit of your children.
And guys, just to show you, to give you an example of how bad this can be, I have one client who, her father passed when she was, I think, in like 7th or 8th grade, okay? And he left a trust behind with several $100,000 for his kids to go to college. And he left the mother as the trustee, okay? So she's the mom. Well, after her husband died prematurely, unexpected, I think that kind of hurt her lifestyle that she was used to, because he was working, he was successful. And her daughter, when she got out of school, applied to a local expensive college here in DFW, private school, got accepted, went to her mom and said, hey, I need the money to pay the first semester of tuition. Her mom started kind of giving her the runaround. She had to hire an attorney and found out that her mom, her own mother, had spent every dime of her trust, and she had $0 at her disposal to use for university. So we can be shocked at times at the self-dealing and the greediness that goes on when people get these positions of authority over money.
Well,
unfortunately.
And unfortunately, there's lots of stories. I mean, my family, my father's side, there's...
People get weird when it comes to money.
Yes, it was very unfortunate.
And so the more safe, and I realize I just told you a story about a trust and things went south, but the more safeguards that we can put in, the better it's going to go, most likely, right? When people don't have a plan in place, it just kind of becomes the Wild West, with the finances after somebody passes. So. Right.
And just last thing, is there anything on the horizon that you know as far as laws that are being changed with respect to inheriting real estate or anything?
No,
talking about?
Yeah. So yes, right now the federal estate tax. So the federal estate tax is one of the few areas that affects everybody in estate planning, because it's obviously a federal tax. Right now it's at an extremely high threshold.
Yes.
Right. If the current president's administration, if they have their way, we're definitely going to be in much more of a pro-tax environment.
Yes.
And so I know that the estate tax threshold apparently will drop dramatically if the current president has his way, which we don't know. The Congress, as we've seen, the Senate in particular has been so tight. There's several kind of Republicans that are a little bit left-leaning. There's several Democrats that are a little bit right-leaning. And so the Senate's kind of obstructed a lot of what he's trying to do. And whether that will happen in this case, I don't know. Mm-hmm. Then we have the midterms coming up, in this fall. A lot of people think that the Republicans will take back the House and the Senate, but we don't know that for sure. But there could be a dramatic drop in the threshold for the estate tax, which means a lot more people would be impacted by it. The way that we can deal with that is through a trust, okay? So a living revocable trust, or an irrevocable trust for that matter, but normally we draft a revocable trust. That's what can be used to help manage and mitigate that situation.
And so what's the current number, or what are they proposing?
Currently, this was passed in 2017 when we had a Republican president, Republican House, and Republican Senate. It's at 11 million for a single beneficiary and 22 million for multiple beneficiaries.
Okay.
Multiple is 2 or more. So it doesn't impact that many people, as you can imagine. But Biden campaigned on dropping it to 3 million.
Oh,
okay. And then probably double for multiple beneficiaries, so it might go up to 6 for multiple, I'm not sure. Whether or not he's going to, again, be able to get that through Congress, I don't know. Whether or not he has to maybe negotiate and they meet somewhere more in the middle. Like under Obama and Bush, it stayed pretty consistent between 4 and 5.5 million for one person and double for multiple.
Right.
But if the bill does get passed, the tax bill, it's going to drop pretty dramatically.
And when we're talking about these numbers, just to explain for the viewers, so 5 million, we're talking about value of the assets that the person who has
everything. Yeah.
And what we're seeing in the Metroplex, as you know, the value of real estate
is
going up exponentially. So
Yeah.
someone's house who was, I'm not kidding, a friend of mine has a house, it was worth 500,000 a couple years ago.
Yeah.
It's worth over $1 million today.
It's unbelievable.
So
Totally
when
unbelievable.
you might be thinking, oh my gosh, that's never going to impact me, but
Yeah.
actually if you look at the equity in your current home,
Right.
and it's continuing to rise along with the other value of your assets.
And you also have to factor in life insurance. A lot of people think, this is another big misconception, is, oh, life insurance doesn't get taxed. Well, it doesn't get taxed directly, but it is considered in your total net worth that you're passing on to somebody. And so that can tip you over the balance too. I mean, you have the value of your home, you have life insurance, your retirement accounts, your savings, and if you own a business, that's successful and has some kind of resale value, all those things get calculated.
Okay, so if anybody has further questions or they want to set up a consultation, I know you actually have another office besides Southlake, so tell
Yes.
everybody where you're located and how to get a hold of you.
Okay, so I have an office in Southlake and I have an office in downtown Fort Worth, and I go back and forth. Probably the best thing to do is go to McGeeLawDFW.com, McGeeLawDFW.com, and that's going to have our phone numbers, email addresses, and all the different ways to contact us. But we offer a complimentary consultation for the first consult for up to an hour, so I'll meet with any individual or family for up to an hour without charge, and be happy to talk with any of you guys.
Great, well thank you so much.
All right,
I appreciate
thank you
it.
for doing this. Thanks guys, take care.